to some judge and some senior lawyers, and they say that previously it was just the circuit court and the district court that was working, but under CJ Wood, Madam Georgina Wood, she then created that at least the High Court, some of them should be sitting, and she created the vacation court. Often, what they deal with was what we call interlocutory matters. Maybe there's a bill application, some interim application motions here and there. Often, they do not deal with substantive matters. But that does not mean that they've not done that before. Like you rightly said, based on the issue at stake,
that's what the
CJ, yes, and that is correct. The CJ can issue a warrant to a particular judge, sit. If the judge says that I cannot sit, or based on health issue or something, then that's fair. But if the judge is willing to sit and a warrant has been issued, we cannot shut down the whole High Court. We cannot do that. So the judge is sitting. What's your issue? Your issue is that you want to proceed on legal vacation. It's fair. As a lawyer, you can decide to go on legal vacation. But the danger here is that the accused person cannot go on vacation when the court is sitting. Are you going to leave your client in limbo? Are you going to do that? You cannot do that. So, in fact, Atachia always has demonstrated. We could see he's a fine lawyer, I must admit. However, in recent times, his commentary has always been something that we cannot write home about. For you, what you can do, a CJ has issued a warrant for a judge to which your case is being heard. You think you cannot sit. You've written a nice letter to the CJ requesting that at least you be exempted from that procedure. It's fair. Anybody can make that. It's based on the CJ to look at it and then agree with you or not. But you go out there to say that it's never done. Hi, I'm going on leave. I'll never show up. It's like before your letter gets to the CJ, you've prejudiced the matter already. You have taken a hardened stand. And to what end? To just pollute the air. In fact, I have sat in court in terms of Judge Kwesi when Godfrey Dame was the AG. And they made an application to say that Judge Kwesi's case should be heard every day. Right? I was in court. Chikata objected.
Because they wanted to expedite the case very quickly.
Chikata objected. That, okay, yes, the client, but he also, as a lawyer, has other cases. So if you want to take his day, the whole day, you're not being fair to him. The judge, Godfrey Dame said that no, it is the interest of every accused person that even your trial should be heard quickly because you claim you are guilty, you are not guilty. So if you are under trial, then they are saying things that you cannot do. For instance, your passport will be seized, you cannot travel. There are certain things you cannot do. So it was even in the interest of the accused person, which in this instance was Judge Kwesi, that says trial should be heard early. So that if he claims he's not guilty and the court acquits him, then he goes home and do whatever he wants to do. Why has the principle changed now? Why don't you want to get your client out? Do you want your client to be under trial for years? For what? To what end?
Is it my, and maybe I'll get 5-star stores when I come to. Is it my understanding that, so, for example, if the case is not heard, Wuntumi at some point gets a bail and goes home? That's what the MPP are pushing for.
No, it depends on the application, and in fact, the application basically pending bail. Yes, and to get bail pending trial, it means that there has to be some. On the face of it, for any judge to grant you that, will be that I look on the face of the judge, I think you are likely to be acquitted. So based on that, I want to give. It's a very tall order for them to get. So the point again is that get your trial as quickly as possible. You've maintained your point. You're pleased that you are not guilty. For me, I'd rather go through a trial for a month to end and I'm acquitted than to wait for 4 years, go 2 days, next week, next month, come, next 2 months. To what end? And my point again is that the issue is very simple. You think you might not be available. It's fair to make the application to the CJ. And in fact, the CJ has the constitutional duty to issue such a warrant because he manages the court in terms of his administrative function. So if he has issued a warrant, you don't go on every radio station, post on social media to say that you will never show up. What authority do you have? What authority do you have? You can resign. You can tell your client you not represent your client again. And I mean, Atacha has achieved that. Even the day of convicting Wuntumi, he was basically not in court. And so it's becoming his normal style. So I believe that the accused persons should be forewarned and probably try searching for a new lawyer to represent them.
Let me get the thoughts of Faisal on this one.